Hey guys, Colleen Balderson here with the English Law Group, an attorney licensed in Kentucky and Indiana, and I am here to talk to you about part two of our two-part series about agency. The last series, we went over the new mandated agency disclosures and disclosures to property conditions that have been implemented in Kentucky with the KREC. And today I want to talk to you about agency law in general. So as a realtor, you have a fiduciary relationship with your client. There are many types of fiduciary relationships a person can have. I, as an attorney, have a fiduciary relationship to all of my clients. If you are acting as an executor, a trustee, a guardian, those are a power of attorney. Those are all agency fiduciary relationships as well. So the fact that we use the word agent and a real estate agent, then that is actually very helpful in showing, or at least, putting out there that it is, there is some sort of fiduciary role. A lot of times the clients don't understand it. A lot of times the agents don't understand it. And I will say that in law school, there is a whole class just on agency laws. The perception, the employee, employer, there's relationships there. There's all kinds of agency relationships, but obviously we are talking about real estate, and I'm primarily talking to the realtors and watching out there in the internet land. And that's what we're going to talk about today. So when you have a fiduciary, and I'm just going to look at some notes here because sometimes I forget all 6 of these. So there are 6 different duties that you have, and it spells the acronym old car. It's obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. So when you are talking about the first one with obedience, you are responsible to do what your client tells you to do. If they want you, if you say this property is the comps are all showing 350, and they said, well, list it for 500. You may say, well, I don't feel like I can, if you're not going to listen to my expert opinion, maybe in a very nice way, maybe you should part ways with a client is that far off. If you decide not to, and you want this listing, then you have to list it for 500. You can document and say, I told you so, but you can't just go behind their back and put on the MLS 350 because that's what you think it is. Okay. Obviously that would be a pretty big breach of this, right? Also means that you have to, you have to try to advise them of the best things in the course of action to do. But at the end of the day, it's up to them to do it. And they can tell you what to do. That gets very, very uncomfortable and maybe unethical and fraudulent if you know that they're filling out that seller's disclosure incorrectly. You really need to talk to your broker about how to proceed with that. You can't, if you see a mold pamphlet on their counter and you know that they just got it, that they've just had some crazy mold test come back, and then they say, well, we're going to fix that, so we're just going to go ahead and say that there is no mold. At the time of signing it, that's wrong information. So you really need to be able to advise them on how to move forward in an ethical way without, it can get kind of sticky there, but you can't just change it behind their back and disclose that. If you feel comfortable moving forward with that, which maybe you shouldn't, but if you do, you can't just change it on their behalf. So the duty of loyalty, this gets, this is really quite something when you're talking about a dual agency, or if you know someone who you're really good friends with on the other side. Maybe it's somebody that didn't use you to be their agent, but it's one of your besties. Where's your duty of loyalty there? You have to disclose that relationship. This is where the disclosure, which is also the third one, but this can get, all these kind of overlap, but it is extremely important that with the duty of loyalty, you disclose if there's any kind of conflict of interest, especially clearly you have a duty to disclose if you are a dual agent or not, or have a family or personal or business relationship with someone now that the forms have changed in Kentucky. With the duty of loyalty, another thing that sometimes people don't think about is, let's say that you are an investor and you also represent an investor and you are looking for the same type of property. If something comes up and you see it, you have to let your client know first. Their interests trump yours. So if you know that this is, oh my gosh, this would be the best Airbnb, I would love it, I want to get into that business, or I'm already in that business, but you have a client that's looking for the exact same stuff in the exact same neighborhood, exact same price point, you might lose it because you got to offer it to them first. That's where the duty of loyalty comes in, that a lot of times people don't think about. So super, super important that you do that. And if maybe you have a partnership with your spouse or something, and an LLC with your spouse, and you guys do that, well, you can't say that you can't submit it to your, let's say the LLC is owned by your husband, and you don't own the LLC. Well, you submit it to your husband before you submit it to your agent. If it doesn't look right, if it doesn't feel right, if something says that you might get in trouble, follow your gut, talk to your broker, talk to your title attorney or any another attorney. We all had to take agency. We all had to get to know it to pass the bar exam. So it's really important that you fully understand that and how some of that overlapping interest can come into play. So disclosure, mainly the disclosure would be that you disclose all offers. You can't say, I'm not going to submit this offer because I think it's a low ball. You might be like, you can't say, I'm not going to submit this offer because I know that my brother is also making an offer and I would rather them choose this offer. Or you might say, you know what, we got 20 offers and these are all really, really low. You have to submit them to your client. If they say, you know what, I don't even want to see them, then send them over and just, they can do with them what they will. That kind of gets into the obedience part, but just make sure you disclose. The number one thing to disclose is if there is a conflict of interest with the other party. The mutual or the dual agency or designated agency aspect of the transaction, super, super, super important that is disclosed, because I will say, as an attorney in real estate, when things go sideways, and I said this on the last video, when things go sideways, the number one thing, because everybody's trying to get people not to breach contracts, the number one thing is that they think that their agent is starting to work for the other side. Why are they pushing me to go closing? I feel like they don't even care about me. Now they just want to get their check, and they're siding with the other side. Well, they might be siding with the other side because you're flat wrong and in breach. I would not say that as an agent, because you're not supposed to advise them on breach. You should always have them call an attorney, but just know that that's kind of where that conversation goes. Usually when somebody is really disgruntled, they want to get out of a contract, they don't have a way out, and now they think that their agent's working on the other side, even if they've never even met any of the other people involved. Okay, so confidentiality, you cannot disclose confidential information. If a party tells you about their financial situation, if they tell you about, or the lender calls you and tells you something that maybe they shouldn't have, you got to take that thing to the grave. You have to, with confidentiality, maybe what's your, especially if you have a dual agency, that can get pretty sticky on what's confidential, what's not. You might want to talk to your broker if something comes up that you really think the other person should know. But that's up to you. I had a phone call the other day about some registered sex offenders in a neighborhood, and the agent really, really, really wanted to disclose that to the other party, but the other party didn't ask about it. She didn't, but it ended up that the client went ahead and put something. You gotta be real careful with some of that stuff, but that is public record. So I would say that if you have somebody where that's an issue and you represent them, they best be looking at the public record to find out where those registered sex offenders are. So the other thing is accounting. It is responsibility of yours to hold on to the settlement statements. You need to hold on to your documentation. That survives closing, and so does the confidentiality. That survives closing as well. So you can't go afterwards and just start talking about your clients and, oh my gosh, they were about to file bankruptcy and whatever. That you need to keep that stuff, within, right there. So, just remember though, that the broker at the end of the day is the client's, representation. So if the broker asks you something, the confidentiality stems to the broker as well, because the broker is primarily like, even though you're the person that they talk to, you're the person that they see all the time, you're the person that they think is your counselor and best friend and everything. The broker is the one who they need to get that information, because they actually, at the end of the day, they represent the client. Reasonable care. That one's pretty easy. You would think, but basically don't be negligent. Don't be reckless. Don't be, do anything maliciously, but mainly it's the negligence part that would come into play. So let's say that you forget a deadline, you forget the inspection. That goes into the reasonable care. You have to try to do a good job. And there's a standard. There is an industry standard that you're going to meet your deadlines. You are going to submit the right paperwork. You're going to fill things out correctly. So the reasonable care is on you. Now, if you have a client who has maybe they filled out the disclosure and they put a certain amount down for a condo association and they accidentally put annual, but it should be monthly. It might be good for you to, read that thing over and just maybe question them on it. You cannot change it for them. They would have to change it, but it might be a good idea to have a set of eyes on those things and actually look at what your client's submitting to you. So these things are really, really important, because there is a ton of examples of E&O coming into play when, you have to file a claim on your E&O, which is never good. It will cost you sleepless nights. It will get a lot of bad reviews. Maybe, some people will say that you've done things that you haven't in fact done. That's a whole other issue, but just, this is your job. This is the outline of your job right there. Everything else is icing on the cake. Okay. So, your responsibility as an agent is all of those 6 things. And it is very important that you take that into account. And if anything seems to be in jeopardy, that you talk to your broker about it. And then it might be that your broker asks you to call me or another lawyer and ask an opinion on something. We get those kind of questions all the time, which I love, because that means that somebody's really thinking about something and they're not just brushing it under the rug. So, with that comes, what do you do when you have conflicting interests? Okay. So let's say that you are an agent for a buyer and it just so happens that your listing is phenomenal and that's a perfect house for them. In Kentucky, it is legal to be a dual agent. You have to disclose that though. So if it's your sister's house that you're listing, you also need to disclose that. But if you disclose it, you can still keep confidential information confidential, but you can't, say, well, I know that they have had this thing. You have to tell them how long it's been on the market, because that's part of the MLS. That's part of what your responsibility is. Looking up some comps in the neighborhood. Also part of what your expectations are is that you're supposed to know whether or not this thing is like crazy priced or not. You can't know what offer the seller is going to accept because you're not in fact the seller, and they may not even know what they will accept, but you would never disclose, I know that the best and final needs to be this, unless they tell you that, like, look, we're not accepting an offer under $6,000. So, you can, if you have the permission of the seller, hey, they're not doing it. So what do you want to do in light of that? So just really important, if there does become something that you think is an overlap of whether or not you should say it, then ask your broker, call me. I will always tell you to call your broker first, but a lot of times it's, hey, I talked to my broker and we have this question. If your broker, if there is more than one agent in your office, there is a possibility of a dual agency. So your broker will always be a dual agent if 2 people in the office are representing a client, because at the end of the day, the broker is the representative. Okay. The others are affiliated agents. Okay. So the broker has two clients, a buyer and a seller, same office. The client needs to understand that especially if the broker is listing the property and then you are the affiliated agent, that there's a dual agency over there, because your broker can't not be a dual agent if 2 people in the office in the same firm are are representing a client, to the opposing sides. Now, sometimes people will say it's a designated agent. So there's a possibility, and you always got to talk to your broker, because most of the time you will just say dual, so that if anything does by chance, if things hit the fan, then they can't say, well, I think you've done this, this, and this. If it's dual, it's a broader understanding that there might be more information shared. Okay. Not confidential information, but more information shared to the parties. It's just an easier way to go through, where it's okay, well, we can't, keep it over here in this box. So designated agent, again, the broker's always going to be the dual agent. But let's say that you have, Sally and Lucy that are both agents within this, ABC real estate firm. It's possible that the broker is going to be a dual agent and Sally and Lucy are going to be designated agents, because they don't talk to each other. They never either go into the office. It's, maybe a remote office, whatever. It's a possibility that they could be designated agents. Most people will default to dual, just because there's a higher level of understanding that everybody's on the same page. Everybody's working for the same thing here. The designated agent is the one assigned to this client, and the designated agent, or the not designated agent. So you've got the agents that are assigned to each client, and then you have the broker that is like the in-between, who at the end of the day, the buck stops there. So please talk to your broker about which way they like you to move forward with those things. Most will just say, if you see anyone from our office on the other side, you choose dual agency as that. And again, these documents need to be presented with every offer, because it could be different with every offer. You might have 10 offers, 2 of which come from your firm, and that might play into what your client wants to do. They might be like, I don't want somebody else in your office making an offer. I want you guys to only represent me. So if something goes wrong, I know your broker's going to go to bat for me. That they may say that. If that's the case, then that's the case. So that's why talking about your the agency, the guide to agency disclosure, that is why that is important, because you can kind of talk about these things. And would you want that? And that's something that they need to, it might change, if they find the right house, or if the right offer comes along, they might be like, I didn't think I wanted that, but now I'm thinking it's a little different. But that's important to know, and to have that conversation before it just comes up, because it's an awful lot to explain if you have 10 offers on the same house. But anyway, so those are basically the rules of agency. And again, it is a whole class in law school. There are classes at GLAR, there are CEs all about agency. So there's way more that we can discuss, but I'm trying to keep this to a minimum. If you have any questions, let me know. A lot of times these things do get very blurred. So it is important that you reach out to your broker, you figure out what your role is. And in that, now that we're talking about agency, in that if you are going to act as a power of attorney, some brokers have complete prohibitions against doing that, being a power of attorney for a client if they're out of town or sick or something. You need to figure out what the rule is there. And then you make the rule for, if they're like, you can do that, then you need to make the rule for yourself. Either you do it or you don't, because you don't want there to be discriminatory practices, that you do it for these clients, but you don't do it for those clients. Well, she told me, but blah, blah, blah. If you are going to be, if you are in fact allowed by your broker, and you have allowed yourself, and I would talk to your E&O about what that means, because that the things that you are signing as power of attorney is outside the scope of representation for a realtor. There's another level there, a whole other level of things that you have to do. And please, just as a sidebar, don't sign anything that your client hasn't seen. Because if we've seen before where maybe it's a UPS pilot and he's in the air and he can't talk. So the client signs as power of attorney, or whoever signs as power of attorney. And in the middle of the closing, we find out, the HOA calls us and it's like, oh, we were wrong. There was actually a new mailbox put in and it's $150. You need to collect that on the settlement statement. Change the settlement statement, power of attorney signs it. The guy lands, and then he's like, what are you talking about? I've already paid that. And he was mad. So then he has to work with, I think, I can't remember if it was before or after we cut the checks, or the checks are out or whatever, but it's something else that could have landed that power of attorney in some hot water. So $150, that's one thing. but some other things could be quite different, and could get really sticky if you get in that situation. So be very careful before you do that. As always, we are here to help get you to closing. We will do whatever it takes within the law to get you to closing, and we hope to see you at a closing table soon.